So welcome everyone. Thank you for attending the second instalment of our Westmead Research Hub Commercialisation seminar series. If you missed the first seminar, please be sure to go to our website, westmead.org.au, and on the top right-hand side, you will see a tab known as Events, from which you can access the recordings. So as usual, you will have a Q&A function, so we encourage all our attendees to ask questions as they pop up and as Reg is presenting. So as I mentioned today, we have Reg Leones from the Children's Medical Research Institute. He's currently an IP and commercialization lawyer who joined in October of 2020. He works closely with the commercialization office there in Julia Hill and Laura Hurigan, as well as the legal in Monica Levy. He worked previously as a solicitor in the IP team at Herbert Smith Freehills and as a patent attorney with FPA patent attorneys. He's worked across a range of technologies, including molecular diagnostics, biologics, generics, medical devices, you name it, he's been involved in it somehow. He's also got a background in biotech and molecular biology, having done an honours year at the Garvan. So with that, I will now invite Reg to share his screen and his presentation titled, Has Your Research Already Been Discovered? And it's all about using intellectual property databases.
Thank you, David. I think I'm online now. Hi, everyone. Thanks again for joining in today. So today's presentation will provide an overview of searching for patents on different databases. And even though it says IP databases, today we are focused on patents because they're the type of IP that's of most interest to our researchers and commercialization officers in the hub. And particularly when researchers are interested in finding a bit more about their technology and potentially commercializing their inventions. So I'll give a brief overview about patents, including the anatomy of a patent document, before going into some of the free online databases and talking about some searches and searching tips and strategies. So just as a bit of a refresher, so patents are, again, an exclusive right granted to an owner of an invention by the government for a limited period of time in exchange for the public disclosure of the invention. So just to remember that they are country specific once they get granted and time limited, usually for 20 years or with some extensions in some cases. And then when it comes to patentability and searching, what we're really interested in is looking at prior art to assess novelty and inventiveness. So whether an invention has already been previously disclosed to the public and whether in light of all that prior art, a new invention is not obvious. So why do we search patents? There are various reasons. As I mentioned, one is to assess the patentability or the novelty of or inventiveness of an invention. Yeah, but yeah, it's not the only reason. So patents actually provide a lot of unique technical information. They are filed a lot of the time ahead of a manuscript that is submitted for peer-reviewed publications. And sometimes they might also contain information that never makes it into a peer-reviewed application. So for this reason, the specification does provide some information that might not otherwise be published or readily accessible. And this gives researchers an opportunity to see what their peers are working on or what other companies are doing in the space, particularly if it's a fairly innovative area of technology, or they just want to gain some perspective on what other people are doing to solve similar problems. Alternatively, the commercialization office or the researchers themselves might also want to conduct market research, so they can track what their competitors are doing in the space, or they might just want to see what other collaborators or academics in other institutions are doing. And this might also help them identify potential licensing or collaboration opportunities as well, particularly if there are some similarities in terms of where people are researching and developing in. And lastly, for freedom to operate, you can search for patents to see whether or not they have granted claims that are valid. And that way you can assess whether or not what you may be doing or thinking of doing, whether it be commercializing a new product or performing a particular method, might infringe those rights. And again, because granted patents are country specific, you'll need to consider the different patents in different jurisdictions. And one thing I didn't mention here is, on this slide, is looking for other patent documents might also help researchers and the commercialization officers in considering what sorts of information they can put into a patent application themselves. So you can see what other people, or how other people are structuring their patent documents to see how you might also think about writing your own application or helping your patent attorney in drafting the application for you. Other things to consider when searching, there is an 18-month window before the earliest patent application is filed and before it's published. So again, you might be in a really hot space, other people are publishing, and you may not necessarily come up against the patent before you file yours, but it may then be published down the line. And when searching for patentability, so novelty and inventiveness, it is crucial that you also consider non-patent literature as well. So journal articles, presentations, and abstracts, not just the patent documents, but today we're focused on the patent documents themselves. So I wanted to remind everyone of the common life cycle of a patent, because when you do searches, you might come across various applications and documents that all have different numbers, but they might all say or disclose the same thing. And the reason is because they are all part of the same patent family. So for example, you might come across, in this example, a PCT application, as noted below. That's filed 12 months after the first provisional application. At that 18-month point, it's published with that WO number. And then at the 30-month mark, when the PCT goes into what we call national phase, it then gets split out into various applications, which are then, each of those are then examined and then proceed to grant. So you can see here that these applications and this publication would all generally have the same disclosure, but in the end, the claims at the end of each of these applications might change depending on how they're examined. So we'll quickly cover the anatomy of a patent, and the reason why it's good to keep the structure of a patent document in mind is that when you're doing patent searches, the types of information and fields that you can search for are also structured, and the databases will allow you to hone into particular fields or combine fields in order to conduct your search. So here, this is an example of a front page or cover page of a US patent. So you can see at the top right here, there's the number of the US patent it's been granted, and that's the date that it's been granted there. And I've just highlighted a few additional fields here. So you can see the title, just a short description of the invention, the inventors. So here there's two inventors. It also notes their nationality, the assignee, so the entity that the patent, who owns the patent. So usually it's a company or the organization. If it's a sole inventor, the inventor's name will also be the applicant or the assignee. But in this case, we have two academics who have assigned their patent rights to the university. Then we have classifications. So patents are classified by number based on their subject matter and type. So you'll see that their patents are grouped according to these subject matter classifications, and it's one way to narrow down or focus a search once you come across a set of patent documents that all have the same patent classification that you're interested in. The references cited on the front cover will also list the patents that have been cited against this patent during examination. So this can help flesh out the prior art. So what other patent documents have come before this one, and what has the examiner referred to during examination? So you can see here there's some additional documents that have been cited against this one. And then in the abstract, so again, just a short summary of what the invention is. So this will give you an idea of what the rest of the disclosure is about. Usually it's quite succinct and descriptive of the rest of the disclosure, but sometimes you do need to go a bit beyond that to get a sense of what it's about. And then behind all this, so in the rest of the text, you've got other sections called that describe the technical field. The background describes the problem area that the patent is directed to solving. And the summary of the invention is usually a description or a high-level summary of what the claimed invention is. So in that section, you can get a better idea of what the invention is about, particularly if the abstract isn't very descriptive. And then in the detailed description, this is where you get the examples and fully described section of the patent, particularly. And when it comes to the examples, a lot of the time, for the biotech and medical science inventions, it will read a little bit like a journal article, because sometimes they've used information from a manuscript that has later appeared in a publication to help support their description. So a few considerations when searching patents. Sometimes multiple numbers are used to describe the same patent document. So something to be aware of, particularly when searching US patents. For example, the same patent that we just looked at was given 3 separate numbers at different times. Each country will have their own unique set of numbers as well. So just something to be aware of as you search. Classifications will be in bold. So again, going back to that previous example here, these are the sort of the top level subject matter classifications that are relevant to this patent. So you can see which of the ones as you come across are the most relevant to your search. And also when you do front cover searches, it's sometimes the database will pull out keywords from the prior art references listed on that front cover. So you may not actually be looking for the subject of the patent itself, but it might just be cross-referencing to another patent. And once again, if you are conducting a type of freedom to operate search and you're interested in looking at the coverage in different countries, it is useful to consider the claims and how they might be different in different jurisdictions. So we'll just quickly go over some of the patent databases that are available. Firstly, the WIPO and National Patent Office databases that I'm probably the most familiar with. First, we have WIPO, or World Intellectual Property Organization. So this links to the PCT applications and also provides links to all the other family members that derive from that PCT. eSpaceNet is hosted by the European Patent Office. And then you have the USPTO and then OzPAT. So OzPAT's for the Australian documents. I probably find WIPO and eSpaceNet the most useful because they have links to information from all the other patent databases and offices around the world, whereas the USPTO and OzPAT, they're particularly focused on Australia and US documents only. But if you were to find the most authoritative information for US and Australia, I would definitely recommend going to those. So we'll also cover briefly and touch on some of the other freely accessible databases. So you have Google Patents. Of the ones here, I would probably go, would be my other go-to, only because of its ease of use and the functionality provided. But I did want to note as well, lens.org, which is co-hosted by Cambia and QUT, because they have some useful tools for searching sequence information, and they also link to PubMed. So if you're looking for journal articles and information from non-patent literature, it's useful to go there. And one other one is SciFinder, particularly if you're interested in looking at information from chemical entities, because you can actually search by structure and the different, and it also links to different journal articles from there. So we'll go through some of the patent search databases to give you an idea of the functionality available. So this is the landing page for WIPO's patent scope. So you can see here the simple search toolbar is displayed. Down here, you can pull down the drop-down menu and search for the different fields that you want to search in. So you can search by number, inventor name, applicant. Here it's got front page, input your search term. And what's useful here is that both in this and in the advanced search menu, the research results will the number of research results that you might get actually come up, so you can play around with your search until you find something that might be useful. And I've flagged the search tool here because when you pull down the drop-down menu, you can select the different types of searches that are available. And so I've selected here the field combination, which is one of the advanced search options. And again, here you've got the different types of fields or data entries that you can put in. And you can structure the search by just limiting it to front page, different numbers, the and or tools here as well. And you can limit then your search strings to just provide lists of the family members, a single family member only. So you don't get, for example, all 15 members of the one family appearing in and cluttering up your search results. And you can click stemming to depending on how you want to do your keyword searches. So for example, instead of fishing, you might only want to type in fish, but still come up with all the other available keyword options. And again, down here, as you do your search, the number of results will come up. So for example, if you put in gene, the word gene up here, you might get thousands of results, but as you add in more information or combinations of keywords, those numbers will go down, or hopefully will go down. And I've done an example search here just to show you what a results list would look like. So in this particular example, I've wanted to find any documents related to microRNA biomarkers. So I've just done a very simple front cover page search for the keywords microRNA or miRNA and biomarker or signature. And you can see here roughly 622 results have come up. Information is displayed for each of the applications with an abstract and the bibliographical information. But if you wanted to then play around with that search and say you were only interested in a particular type of cancer, you could add in an additional keyword. And in this case, the number of results has gone down to 30. So you can see just sort of playing around with the search bar up here might help narrow down a search. And this is just an example of if you did click on a results, one of the results, what you would see. So again, you get taken to the bibliographic information for that particular patent. You can click on the different tabs along here to find out some more information, including downloading documents like the patent document itself. Before we move on from WIPO, I wanted to mention that WIPO also hosts the database for the intellectual property, the international patent classifications. So as I mentioned before, on the front cover, patents are given a particular classification depending on their subject matter. So if you wanted to actually find out what that classification was or was directed to, you can click through or and browse the different classifications or type in the symbol there. So for example, if you keep coming across G06, I'm quite familiar with that because it's software. So software patents all tend to fall within the code G06. You'll be able to see what other classification codes fall within that, that symbol. So now we'll go to eSpaceNet. So this is the landing page for the simple search function. So you can just put in a search term there. If you were putting in a number, you do need to include the country code. So if it was a US number, you'd need to have the US at the beginning. And you can click on the advanced search function here and you will get taken to this page. So again, with the different field combinations and or search terms, you can build your search as you go. I tend to use eSpaceNet to find out more information about a particular family or particular patent and their legal status rather than doing prior art searches. I'd probably use either the WIPO patent scope or Google for that. But what I'll show you is on eSpaceNet. This is the same patent that we had just looked at on WIPO. I've just searched for it using the search term. It's brought up that Australian patent. And what you can see is that if you wanted to see what other patents are in the family and their status, what you could do is go to click on patent family, and then click on Ippendoc family, and you can see here all the family members are listed. So not only is it filed in Australia, but if you brought this up on your own screen, you could see it's also filed in Canada, China, Europe, Japan, and there are a few applications in the US as well. And then from here, you can also click on Global Dossier to bring up the legal status of that particular application, so you can see where it is in terms of its status during examination or prosecution. And another way to do this is by clicking on latest legal events. So I've clicked on that. And this gives a bit of a snapshot as to where all the different applications are. So you can see here, even though it was filed around the world, a lot of them were either withdrawn during examination or proceeded to grant, but then expired, because I guess in this case, the patentee, in this case, the university might have decided to let this particular patent family go. So what this means from a freedom to operate perspective is that if there are no valid claims that are still enforceable, because the patent is still alive, then there is a greater chance of not infringing the claim. But when it comes from a patentability or novelty perspective, what you need to consider is there information contained in these documents that would still render your potential invention not novel or not inventive. So, and we'll touch on that again a bit later. On the USPTO website, again, I mentioned it's very focused on US documents and information. So I've highlighted here the ones that are probably the most useful for people. One thing to note is the US database does split its information between the patent applications that haven't yet been granted and then the granted patents. So if you're clicking on any of these and looking for a particular number, you need to make sure that you're looking in the right one. And in terms of looking at the patent status and where it is during examination, patent pair or PAR will have the relevant information. So you can, again, track through where the patent application is, and you can also obtain copies of the examiner's reports and arguments that the applicant has made in response to those reports. And lastly, patent assignment search for those in the commercialization space. You might be interested to see who currently owns a patent or whether or not the patent has been licensed, and that information is generally recorded and searchable in that database there. Lastly, on Google Patents, again, I mentioned it's a relatively easy to use database with a lot of functionality. I've rerun the search in this example from the one we did in WIPO. But you can see here, rather than just 20 results, we've got thousands. That's because the WIPO search was limited to that front cover page search, whereas this Google Patent search is across the whole of the description. So it's pulling out any sort of keyword where that any sort of result where that keyword appears. But you can, with these search fields here, add in further limitations and information to help narrow down that search. And you can play around with this results list toggle that will either expand or increase or minimize this results tab here. So you can navigate a particular result as you scroll through the research or the results list. And this, again, just is a further example of what would happen if you clicked on one of those results. Here you can see there's the abstract, the images. You can scroll through and select, and if you select one of these images, it will expand. It has links to all the other patent offices. So again, it's quite useful because you can get further information from the USPTO, or you can link through to eSpaceNet. You can also download the relevant information, the copy of the patent document, and it's got the description and the claims set out below. And one thing I didn't take a screenshot of, but if you did scroll down in a results page, you can get links to all the other patent citation or all the other forward or back references. So any patents or journal articles that refer to this patent and similarly any patents or journal articles that were cited against this patent. So it's a good way to sort of go forward or back from this patent to see what other prior art is available. And that's useful if you are doing that prior art search, particularly for novelty or inventive step, to see what else is out there after you find one that looks relevant. So going on to some simple search strategies and tips. So again, one thing to keep in mind is the type of search that you are doing. If you are considering novelty or inventive step, you need to really think about what is described in the whole patent document and structure your search accordingly. If you're looking at freedom to operate or infringement, once you find some relevant documents, then you need to focus in on the claims, particularly determining whether or not they're enforceable, and if they have the features that you are also interested in including in your own invention or included in the product or method that you're interested in performing. Some databases, for example, WIPO, they do allow you to search by claim only. So if you are particularly interested in narrowing a search in that way, that's one option to do. And if you are just looking for a particular patent or the status of the patent, then that's a little bit easier, because if you've got the number in mind or the applicant name in mind, then you can search using the field options for those. So again, these are just the different ways you can build a search. So classifications, numbers, keywords, inventor names, or assignee or applicant names as well. So generally, I would probably, if you're doing a prior art search because you were just interested in a particular area, I would recommend thinking about the keywords that you could use, maybe look at to see what the top filers or the companies in the space themselves are filing, particularly if you're looking to see, or particularly if you're inventing something that is generally known to be a product or a service by a company that's out there. So when you're looking at structuring your search or putting together a keyword search, there are a few key questions to ask to help come about the keywords that you would use. One is thinking about what the invention is that you are yourself developing. What results are you looking to achieve? How does the invention work? And what does the invention affect? So you might be looking at a particular disease state or an indication or a target. And again, there might be one or more different ways to describe each of those keywords as well. So think about synonyms for a word, terminology that's not only used by other researchers, but what the average person or the scientific media might also use. And if you are thinking about brand names or drug names, for example, the brand name itself may not be used in the patent, but the scientific name is most likely the one that they are using. So just to keep that in mind as well. And a few other things to note, that not all the databases are the same. So as I mentioned, US and Australia databases, they only really focused on their respective countries, whereas the WIPO and the eSpaceNet databases link to other jurisdictions. And not all of them will have the same coverage in terms of years as well. So that's just something to keep in mind. There are errors that appear because sometimes the patents are uploaded and machine scanned. So there will be some errors that appear, particularly if you're looking at the full text sections of a patent entry. And if you are thinking about doing a very targeted and important patent search for novelty, and particularly for freedom to operate or infringement, one thing to think about is engaging a patent search company or an external patent attorney. There are companies out there that are dedicated patent searchers. But that one thing to keep in mind is then the cost benefit of engaging an external company to do that type of search. And one last thing is, searching is a bit of an art. There are, as I mentioned, people who are experts in searching. So it does take a bit of time to sometimes come up with the right search strategy. But if you are a little bit familiar with, for example, keyword searching for journal articles, then you can apply a similar strategy when searching on patent databases and performing those keyword searches. But sometimes it does take a little bit of playing around in terms of keywords and numbers to see what works. But one thing to keep in mind as well is that each of the databases have their own how-to and help guides. WIPO, for example, has a whole set of videos about how to run searches on their website. Yeah, so it's quite useful there if you are not too sure where to look, or if you just need a few extra tips on how to build your search. That was all I had at the moment, but I'm happy to field any questions. Oh, I've got a question here from Anonymous. So I guess as researchers particularly, I think that when looking for patents in this way, it's one way for you to get a bit of an idea of what's out there. But I guess it depends on each institution whether or not the Commercialisation Office would have the capability to also help in that sense. I mean, I can't speak for all the commercialisation officers, but some might be able to help out, or they can work with you to then engage an external company to do so.
Reg, I just had a quick question. You mentioned the pipeline from provisional through to PCT and whatnot.
Yeah.
Are you able to provide any sort of indication of how expensive that process is, and I guess how much work goes into each of those steps?
Yeah, let me just go back to that pipeline. I can give you a very high level. This is definitely not a cost estimate by any means.
No, of course. Yeah.
Yeah, so at the moment, I guess what the PCT timeline does help with is that, for example, if you're looking to file a provisional application at this point because you've got some really promising data, but you're not too sure whether or not you want to proceed, or you might be interested in looking for a commercial partner down the path, what you can do is file that provisional. That, again, it depends on the technology and the amount of work involved, but that provisional can cost anywhere from a couple of $1,000s all the way up to 10 to 15. Again, depending on how substantial that provisional filing is. You then have that 12-month window to then supplement that provisional filing with additional information, because, for example, you might come across some more data that supports another indication, or just helps support the strength of the claim. So then at that PCT stage, you're again looking at anywhere from $5,000 to $8,000 to complete, depending on how much work is involved. If, for example, there isn't a lot of work to be done in between here, then you're essentially then filing the same application again. So that cost would be a lot less. But so, yeah, I can't say off the top of my head what it would be, but yeah, it just depends on the amount of work to put that filing together. But if it's really just putting the same thing in, but formalizing it as a PCT application, that cost would be a lot less. The costs at this stage are relatively low, depending on what happens. The PCT then is published. For example, here is this WO publication. It then undergoes a formalities and search. And what comes out of this stage is a preliminary, international search report and a preliminary report on patentability. So what a patent office will do is do a prior art search, so a much more detailed, in-depth search than the ones that I've talked about today. And what will come out is a set of prior art that will give an indication as to the novelty and inventiveness of the claims as they sit at this stage. Now, at this point, the applicant can decide to just sit on that report and not really do anything, or they can seek to engage and amend their report and actually respond to the international report on preliminary report on patentability. That would generally happen in very particular circumstances. I think most applicants tend to wait to see what happens down the line, because that international report isn't necessarily binding on any national patent office when it comes to examination down here, but it may influence one or more of the patent offices in terms of what they then say during their own respective examinations. So then really it's at this point, national phase entry, that the costs start to ramp up, because basically at this point you need to file a fully fledged application into each of the jurisdictions that you're interested in entering. So here I put 153 being the number of patent cooperation treaty countries that are available. I guess most people would focus on the main trade areas that they're interested in pursuing. So Europe, US, Australia, and China. One thing to mention in Europe is that when you file the European patent, it's a regional patent application. So it's examined by the EPO, or the European Patent Office. And then after that examination, it's then nationalized into each of the other jurisdictions that are part of the EPO framework. So it's after this European application is examined that it then gets split off into, say, Germany or France or the UK. But yeah, because of each of these applications from here on, there'll be a cost involved in filing the application, and then costs involved in actually having that application examined and responding to each of the examination reports as they come through. Then if it does get through to grant, which hopefully it does, then there'll be maintenance fees on top of that. So there'll be annual fees that the patentee will have to pay. So again, going back to your question as to how much this would cost, again, with each and every application at that initial filing point, it's again anywhere from that $2 to $5 or maybe even more $1,000 mark. But at prosecution stage at each patent office, that's when the costs really start to incur, because not only are you paying for the official fees, but then you're paying for the patent attorney or the lawyer, patent lawyer fees, who are then having to respond and engage with each of those reports and looking after the filing on your behalf.
Fantastic. Thanks heaps for that, Reg. We've got a few more questions coming through. The first of which is, which database would you recommend going to first?
Sometimes I just use Google without even going to a patent database, because sometimes you might not know it yourself, but Google might link to a company's webpage or publication or product, and you might actually see that there's something already out there. So and that might then lead on to help a patent search by focusing in on that company or the keywords that they use on their webpage or their journal article to then help you when doing your own search. And then in terms of structuring an actual patent database search, I would probably use WIPO, because that's, for example, that field combination search. I'll just go to it on my slide. Yeah, it's quite helpful, because you can play around with, for example, front page. You can scroll down to claims or detailed description, and you can the Boolean search terms are quite useful to then build into this search strategy here. I have another question around, is access to all the patent databases free of charge? So the one I've mentioned in these two slides, they're all free. Yeah, you can access any of them without having to necessarily log in. Some of them you can create an account. For example, WIPO, I think USPTO, eSpaceNet, you can create accounts, and that will just help, for example, with saving search strings or If you wanted additional functionality, I think that's where it comes into play. But if you just wanted to quickly dip into them and do a search, that's fine. And that's the same with Google as well. I think the only one listed here that might require a login is SciFinder, but if an academic institution might have an access or licenses to that, that's one way to use it.
All right, fantastic. If there are no more questions, we might wrap it up there. So bear with me as I share the screen with you all. All right, fantastic. So hopefully you should all see that. So thanks again to Reg. I really appreciate you taking the time to take us through these patent databases. So the slide you see on the screen now is just essentially the commercialization, tech transfer and business development individuals across the Westmead campus. So depending on which institution you're from, if it's New South Wales Health Pathology, the Kids Hospital, CMRI, all the relevant information on your go-to contact can be found on the Westmead Research Hub website. So that's at westmead.org.au, and then at the top right-hand side, you'll see a panel called Research, and then click on Research Commercialization to get those details. So with that, I would just like to thank all of our attendees for coming. The next webinar will be on the 7th of July, 2021. And it will be entitled, Have You Ruled Your Chances at Securing Intellectual Property? And it's all about disclosure. So with that, I would just like to thank you all again for attending, and I really appreciate you listening to our seminar series. So until next time, take care, everyone.